This is The Good Fight with attorney Steve and Josh. All right. How's it going?
Too long.
What happened?
So it's been too long.
It has been a long time. Actually, our viewers may or may not see this or will be able to see this, but behind me I've got my green screen. I've had it for the most part of today, a picture of our last podcast, which was episode number 16. So the one we're shooting right now is number 17. But anyway, the point is that it was shot pretty much right when COVID-19 hit and permeated our households and, forced a lockdown, a quarantine, which is still in effect.
Yeah, I think I was 2 days after we closed the office.
Yeah, because the topic then was COVID-19 can't slow us down, and it has an update, everybody, and it has not slowed us down.
It has not. I think we've been busier on some fronts.
Yeah, and we've gotten a lot stronger. You wanted to provide our listeners with a little update with the last episode. What kind of update can you share with everyone? Everyone, thanks for tuning in, by the way. We appreciate all the listeners, all the love on The Good Fight with attorney Steve and Josh. But, for example, we love Zoom. In fact, we're shooting this in part with Zoom.
Actually, I think the last time we were using Legler still, and that was a disaster.
Well, Zoom, there's so many features, so many capabilities.
Well, and very quickly, we needed to become, I guess mobile is the right word, right? Because we needed other people to be able to use what we were using outside of our office.
Yeah.
And so everybody else is using Zoom or Blue Jeans if you're at a big corporation or something like that.
Mm-hmm.
So it was the obvious choice.
Yeah. By the way, everybody, if you can't see us, we're still shooting this remotely. I'm at my house and Josh is at his house. You do sound a little differently, and I think that's because you're using a new rig setup. What's it called?
Yeah, it's called a smart rig.
It's basically a USB-C interface that connects here. You sound good. You sound fine. For some reason, when you tried it earlier,
convincing.
I know, right? It sounds it sounds a little different than what you were when earlier today. You used that mic and you sounded. I don't know how you were. Maybe it's because of the clean feed. Yeah, we have to use. I'll research some more. Maybe there's another way to do remote podcasts without using clean feed. But
yeah,
and maybe the end result will sound better.
I'm not a huge fan of this clean feed thing because there's delay in my headphones when I hear myself talk.
Yeah,
so I have one headphone on, one headphone off because it's driving me nuts. I'm getting lost in my senses. Yeah,
well, I'll play with it a little bit more. But this is our second podcast, and how long has been? So today is Wednesday, May 13th. So I feel like we've been in lockdown forever, but
it's 2 months.
Yeah, Jesus.
My wife's been on lockdown since the 13th.
Well, that's the other thing I wanted to mention, which is the other sort of neat thing about our podcast today is that any moment now you're going to be a father, literally. Any moment.
Scary thought.
It is.
Gotta get a license
in a good
to drive
way.
A car. Gotta get a license to get a dog.
Yeah, in a good way.
Oh, you could have 17 of those if you want.
This is actually a perfect segue. I didn't even intend it for it to be this way, which a lot of this isn't scripted at all, by the way, folks. But COVID-19 and children, because that is the topic of today. Let me pull up my notes here. So we had a couple of working titles, I think, Josh, right? When we brainstormed about. But today's topic, everybody, is called COVID-19 as an excuse to deny child custody and visitation. As you listeners, some of you might know, we do personal injury, family law, and bankruptcy. And we should definitely have a bankruptcy talk. I know we've been talking about it a lot now, Josh, but now that the unemployment rate is, Jesus, what is it now? 14, 20%, 60%? Yeah. Crazy, astronomical. Yeah. So I think we're going to see a lot of waves and a big wave in bankruptcy, I think.
We should just clickbait the title.
Well, that's pretty clickbaitable.
Name it COVID-19, what your ex doesn't want you to know.
Yeah, I know. But so we've seen it personally on our cases, Josh, and so what by that I mean, um, we have a client who's a male, custody case, and we actually, so she tried to get a restraining order against our client. That's how we became involved in the case, and it went to trial. These family law cases are not jury trials; they're bench trials. It was a short trial, but through evidence, we were able to successfully establish that the mom, was just trying to obfuscate and fabricate, really, in my opinion, and alienate. And it's part of the systemic pattern of alienation that she was trying to, fool the court into thinking. Anyway, she was trying to show that our client had abused this little boy physically, something like that.
Yeah, there was allegations that were what she thought were substantiated by some video evidence that she had, when really there was. I don't even like talking about it because it's just so disgusting to me that she would do this to her young child and put him through this. And
well, the judge admonished her.
I don't want to get into the details.
Yeah, and she reamed her.
Talk to a party like that before ever,
and we have the transcript. It was great. Anyway, after that hearing, after basically the mom walked out of there with her head down and her tail between her legs. Thereafter, that's right about the time that the quarantine started and the stay-at-home order started. But anyway, she, in my opinion, Josh, is used and is using the COVID-19, stay-at-home order as a pretext, as an excuse to deny our client court-ordered custody and visitation. And so now our client hasn't seen this little boy, and I think 3 months now. And so, anyway, I know you and I kind of have differing views on this, and let's get into it. How do you
feel? Let's talk about this specific case from a practical perspective.
Sure.
You got to remember that the DVRO and the actual family law case are two different courts.
The domestic violence restraining order case and the custody case.
It's kind of an unusual situation, right? Because if she was smart, she would have filed the domestic violence restraining order in the same court as their family law case, but she didn't.
Well, right? I think. Well, she did that intentionally, I think, and so did the judge.
Yeah, I think so too.
Yeah.
But so like this systemic approach that you're talking about, it loses a little bit of credence because this judge isn't going to be privy to what happened here. He's going to see it on a transcript. Maybe if he reads the whole thing, we attach it. But this. If we were in the same judge as the DVRO and this was going on, there'd be no issue whatsoever.
Yeah. But I mean, how do you feel? Yeah, but we've also, let's talk about this idea of using COVID-19 both as a sword, or I'm sorry, using it as a sword or a shield. What do you mean by that, Josh? When we talk about what does that mean in the context of what we're seeing with the stay-at-home order and custody and visitation rights?
So I think that as a sword or as a shield, it's all just based on the best interest of the child, right? And it's all about framing and about putting into context, especially in these family law cases, right? It's all about context because these judges, they hear soap operas all day.
Yeah.
Right? And so you use it as a sword when you want the best interest of the child to be, I want them to stay home, right? That's when you can use it as a sword. And the same goes for a shield. But that's really what it is, right?
Mm-hmm.
So let's continue to use this example, right? The case that we're talking about.
Okay.
The opposing party has done a good job here of using the facts in her favor, right? And what's going on in the world to her favor.
Right?
The child has respiratory issues, right? He's got asthma.
Undisputed. Sure. Undisputed. Yeah.
Breathing treatments, all sorts of things.
Sure.
And so her position is he can't go out of the house. He shouldn't be out of the house because we're increasing the risk to exposure, right? Because he's going to a house where multiple people live. There's a court-appointed monitor that lives outside the house. So the exposure levels are heightened. Okay. why she's done such a good job, and I don't think she did it purposefully. I just think it's a product of the environment. We would look ridiculous to go in ex parte and say, me seeing my son is more important than the risk that I'm going to put him through.
Yeah. Well, I think that if we were to look at this case in a vacuum, I probably would agree with you. But knowing, this particular case and what she has done prior to even COVID-19 to alienate the father-son relationship in this case, I just can't agree with you. Does that make sense?
Yeah, it makes sense. But I think that we have to look at it in a vacuum, because I think that's how judges are looking at it,
Mm-hmm.
right? The last thing the judge wants to do here in any situation, whether it's this specific case or one of our other cases where we're dealing with the issue of travel, right? The judge has to make the decision, am I going to put this child at risk of exposure?
Yeah.
Right? That's the inquiry. It's not what has mom done in the past, what has dad done in the past, because mom and dad are not creating this risk, right?
Mm-hmm.
The disease, the pandemic is creating the risk.
Right.
So it's really hard for a judge to say this is just systematic, this is just her trying to keep, child from father, when, everybody's staying at home, literally businesses are closed, like, it's hard to differentiate the two.
On the flip side, however, we do know, and we have clients who, even during this stay-at-home order, are co-parenting. You want to call it that, or they are maybe not even some are co-parenting, but some are exercising their custodial rights. Without, or at least we're not seeing this pretext, as I call it, or excuse of, I know what the court order says, but I can't unfortunately follow it because I'm afraid that our child or our children are going to be unnecessarily exposed, or they could get COVID, et cetera, et cetera. So
let me say this. First of all, I'm shocked.
Why?
Right? I'm shocked that we don't have more clients in this situation.
Mm-hmm.
I thought it was going to be much more combative during this time.
Yeah, me too.
So I'd be very curious to see what other family law practitioners are dealing with.
Yeah.
I've gotten more calls about how to split the stimulus check than about, wanting to take the kids or not taking the kids to the other party for their custodial time.
Yeah.
And I don't know if it's because everybody's at home and they want a break from their kids. I have no idea.
We also have another case, a client who, so we represent in this case as well, we represent moms and dads, but in this other case, we represent dad, and mom wants to go and visit her mother in another state on the East Coast, on the other side of the country. I won't name the state, but it's on the other side of the country. And the point is, though, that she wants to do this in July, which actually is kind of relevant, I think, just because of the timing, right? But our client wants to prohibit that move. And by the way, actually, this is a good example because they have been exchanging this small child.
This is the one I'm most shocked about.
50-50, they do have 50-50, and they do exchange a kid it's a 1 week on, 1 week off basis. But our client, all of a sudden, or not, wants to prevent this travel to the other side of the country. So
I don't think it's all of a sudden. I think, so let me preface this by saying I'm shocked because this is a high conflict.
It is high conflict
matter. Okay, so I'm shocked that we haven't heard from them regarding not wanting to exchange during this time. That's shocking to me.
Right. I understand.
I don't think it's all of a sudden. I think that it is based on, I think our client just assumed that she wasn't going to travel during this time. And then when she notified him that she was going to continue to go forward with the travel, he jumped on it right away.
Yeah.
Our client's pretty diligent when it comes to the minor. I
He
think
is.
this is something he would have sat on.
Yeah.
So,
And I guess that's not that I have a point or anything, but, I just fear and I worry about people abusing the, current state of world affairs or whatever, in an effort to, like not have the other person spend this quality time with the child.
It's the ultimate. What do you want it to be?
Yeah, exactly. What do you mean by that,
It's
Josh?
the ultimate. What do you want it to be? There's the joke that person asks a mathematician, "What's 1 plus 1?" And the
Mm-hmm.
mathematician says, well, it's not actually 2, it's actually a little bit over 2, right? And then he asks a scientist, and the scientist, well, it's actually a little bit less than 2. And then he asks an attorney, and the attorney says, he says, close the door, come in here, shut the blinds, right?
Mm-hmm.
What do you want it to be?
Right.
Right? And that's the situation here, is that it's whether it's right or whether it's wrong, it can be framed in either way.
Right.
In one side, you can frame it as this is a systematic, way to keep away the child from dad, ultimately alienating him.
Right.
On the other hand, it can be framed in this is the best interest of the child. It's obviously dangerous out there. There's new medicine coming out every day that says, children are more susceptible than we thought they were originally. If kids aren't going to school, then what makes you think they should be being exchanged?
Yeah.
There's arguments to be made on both sides. And I think it is actually very good that the courts are in the situation they are right now, where they're not hearing these matters, because it would be a mess.
Mm-hmm.
It would be a mess.
Yeah.
There would be no guidance whatsoever.
Well, we haven't litigated this exact issue, but we may closer to July, regarding the case that we're talking about right now.
So let me say something real quick.
Mm-hmm.
Although it's not being litigated now, and although it's the ultimate, what do you want it to be?
Mm-hmm.
At some point, these cases are going to get back in front of a judge. And at some point, the best interest of the child is going to be back to what it is, right? And it's going to be baseline. And whatever's done during this time period is going to be put under the magnifying glass.
Yeah.
Right? If you use it improperly and you have that history of systematic abuse of the system, it's not going to bode well for you.
Mm-hmm.
That's just the reality, right? This is just a time where the wheels of justice are going to be very slow.
Yeah.
But eventually, right, the truth comes out.
Yeah.
And
well, I think in this,
you have to be careful.
Yeah, you have to be careful. In this latter case that we're talking about, I think because you're dealing with travel on an airplane, going to another part of the country where I believe it was a hotspot or is a hotspot in terms of spikes and cases and all that, right?
There's like 5 states where the numbers are declining. So,
but I think because of those 3 factors, though, this is a legit concern that our client has.
Well, and I think to really put the nail in the coffin is what essential travel is going on right now for a minor.
Yeah, well, exactly. That's a perfect terminology, because it's all about whether it's essential, whether it's necessary to travel. Now, let me add another, I don't know, we don't have this case, but let's assume that, it's regarding a funeral or something where this child had a strong connection. Now, would your analysis change then? Would a judge's analysis change then?
I don't think so. That's what I'm saying. I think that the decision right now for judges is being made in a vacuum. I don't think they have a choice.
Yeah.
I think they're going to apply it later, right? If it's applicable to the disposition of the case for the long term, it'll be taken in the light that that's necessary.
Yeah. Yeah.
By the way, that's Steve's daughter tap dancing.
I know. I was just gonna say. My daughter's literally doing tap dancing classes
for the
on
record,
Zoom.
I'm having a girl.
Yes.
And she will never own a pair of dance shoes.
Oh, you're making it official on the record, huh?
Oh, on the record.
Wow. I can't wait to play this podcast back in, 10, 11, 12 years when your daughter's making the choice of dancing at Heart Academy of Dance, just like your sister-in-law, Morgan.
There's a better chance of me waking up 6'4".
Oh, boy. Well, how does your wife feel about that, by the way?
She agrees with me.
She agrees?
And she danced her whole life.
That's true. Interesting. Okay. Well, this is probably a good time to start wrapping up our call, since I apologize, everybody, for that tap sound, because it is, Josh is right, it's my daughter tap dancing. But yeah, it's an interesting issue. In closing, I think it's a very fascinating topic, because I feel like, I've been thinking about, I've been listening to a ton of webinars, and our colleagues, our trial lawyer colleagues, talking about jury selection. Today I was listening about jury selection, and I was lately been thinking about, our everyday routines and our interactions with other human beings, whether it's potential jurors or your wife or your parents or your professional colleagues, whatever. And I was thinking about kind of how I'm thinking about this idea, and I'll formulate it in a poem or something, or in a song, or in something. But
please be a poem.
You want to be a poem? Just how when you
haiku.
You can have, certain, let's take it a court order or a set of facts, and when you start adding emotion and heightened emotion and conflict and these other elements of maybe a long history of discord and animosity, right? When you start adding those things, that's when you can take an otherwise like middle down the road objective, what would appear as black and white, and then it doesn't become that anymore, right? And that's how I'm viewing this whole topic that we're talking about today, as far as a court order for custody visitation. It should be black and white. It should be kid goes with you on this week, kid goes with me on this week. But when you start adding these high conflict feelings and angst and animosity, then it's like exactly what you said. What do you want it to be? Like, what do you want to do? And here's a way, COVID-19, to use it as a pretext to get something else out of it.
To me, it's very simple, right? And I tell this to our clients all the time. Our job as attorneys is not to take emotion out of it, right? It's to both take emotion out and inject it when necessary, right? We are the keepers of the emotion, and we have to know how to utilize it to benefit our clients.
Right. Yeah.
But I think, for me to close up here, this is a very trying time for everyone,
right?
No matter the situation.
Yes.
And it's very easy to get caught up in, I can use this as a sword. I can use this as a shield. I can frame this in a way that's most favorable to what I want right now. But at the end of the day, like I said earlier, it will come to light why it was used that way and how it impacted the case as a whole. So I think my sentiment is the best interest of the child doesn't change because of what's going on, right? Only your perception of it does.
Exactly. Just for me, it's like, just do the right thing.
Exactly.
Especially when you and I are having these, we meet multiple times a day through video conferencing, right? On that first case that I'm telling you about, like, it wasn't until recently when she got a lawyer that she started doing these FaceTime calls with the child. It's like, really? It takes a lawyer for you to do that? But that's my argument. It's like this part of the systemic abuse, really. Yeah. Right? Because there's ways to, if you're really, fearful of this risk of exposure to COVID and this and that, then figure out another way to still have the child have a meaningful relationship with the other parent. There's ways. There's ways. There's ways to do it.
But it takes co-parenting.
Yeah.
Right? And if there was a willingness to co-parent and put differences aside and worry about the child, you and I would have a lot less cases.
A lot less clients, I know. Yeah, no, I know.
It's just, the reality.
Yeah.
And that's the emotion part of it.
It's a good problem to have, I guess, for us.
Okay.
All right. Huh?
It is what it is.
It is what it is. I love that joke, by the way. I think you hadn't heard that joke before you met me, had you? The joke with the scientist and the lawyer and hey, close those blinds. Come here. What do you want it to be? That's a great joke.
That's the conversation that adjusters and defense attorneys have.
Yeah, exactly. All right. Well, thanks again, everybody, for listening to The Good Fight with Attorney Steve and Josh. We hope you're all being safe and sound, and stay safe.
We'll be back sooner this time.
Yeah, definitely. Oh, I forgot the gavel. I should tell my daughter to tap dance to this song. Hell yeah. She's giving me a dirty eyeball look. All right, we'll go have a baby.
I'm trying, dude.
You trying? I hope so.
Yeah.